Perfect. All right. Well, welcome to those in the audience and participating by webinar, and also to those of you watching this later via YouTube. Today we'll cover top 5 tips for small businesses relating to intellectual property. And to kick off, just the standard, I'm a lawyer disclaimer, but I'm not your lawyer yet, so no legal advice that would be construed as a formal attorney-client relationship today. So first I'll lead off with what I'm going to tell you, and then I'll tell you things, and then we'll close with a summary of what you heard. So top 5 tips in a nutshell. The first one is think big, and that'll be the most time we spend in the presentation, thinking big. The second one is think before you put that in writing, and we'll go over why that's important. Think offensively and defensively. Think long look, and why that's important for your business as well as for intellectual property. And then last, and appropriate for the partnership luncheon today, think partnership. So think big, like last week's turkey. People tend to think of IP as one really narrow area depending on what their business is in, but really it encompasses a lot. And why it's important and why you want to think big is intellectual property is what changes your ideas into revenue. It's what turns your knowledge, your know-how, your secret sauce into how you make money, how you create jobs. So you want to use it to establish a proprietary position, protect your research investment, enable investors to have a reason to say that what they're investing in is going to yield final commercial results. Intellectual property, if you discover something tangential to the area you're working in, can be useful as a bargaining chip in negotiations later on. So you might have IP in an area that you might not want to sell, but it might be useful to talk to others and see if you can get a cross-licensing agreement, for example. And then sometimes patents, as one example of intellectual property, are important just as a recognition of technical achievement, and useful particularly for small businesses to showcase their technical know-how. If you can say, hey, I've got 3 patents in this area, that says something, and that can be very useful to potential investors and useful in your marketing. So I think we lost, there we go. There are many different mechanisms of IP protection. And again, we tend to think of patents, or at least maybe I tend to think of patents since that's the area I practice most, and along with licensing. And I'm a patent attorney, so that comes to mind. But I want to talk about the other areas of IP in addition to patents. And we'll use the Hershey's Kiss as an example. So the Hershey's Kiss is one product, but it's covered by a number of mechanisms of intellectual property. You don't have to pick one. So just as Pioneer won the US Supreme Court case that decided that a plant can be covered not only by a utility patent, but also by a plant variety protection certificate, here the Hershey's Kiss is covered by multiple forms of IP protection. So there's a trademark for the shape and to the name. There's a patent on the methods of cocoa production used in the Hershey's Kiss. They obviously hold copyrights on their advertisements. The actual formula itself is a trade secret. And then they have contracts with their distributors, with their manufacturers, with their employees that help protect all of that intellectual property. So think big, and don't let yourself get boxed into just one area when you're thinking about IP solutions. So now we'll have a quiz, and because I don't have a Hershey's Kiss, we'll give out this lovely mug. To those of you on the web or on YouTube later, we'll have to figure out something else for you. All right, so which of the following is not true, okay? A, in the United States, the right to secure a patent was established under the US Constitution. B, every Tuesday, the landscape in the US and the patent world changes. C, under current patent law, the first person to invent something has the right to patent the invention. Or D, performing research on a patented material, even when you didn't commercialize the product, has resulted in a $1 billion patent infringement verdict. So which of these is not true? Does anybody have a guess? Yes? Yes, C. C, you are correct. So there was a change in the patent law in the US. It used to be that if you were the first to invent, that would enable you to have the right to get the patent. Now we've moved to be consistent with the rest of the world to a first to file system. So filing first is very important. And so you are the proud winner of a mug. I usually get somebody who says it's A for constitutional law, but nope, we are constitutional lawyers, those of us who are patent lawyers. All right. So what do you need for a patent? What are the requirements for patentability? What are you thinking when you sit there and you come up with an invention or you have a scientific discovery and you say, wow, could I get a patent on that? And I'll talk later on about why that isn't the right question to ask in the first place. But when you talk about filing a patent, what the requirements are, we'll cover 5 here. So first of all, a patent is the right to exclude others from practicing your invention for a limited period. It's not the right to make it. So it could be that you have a patent on a very particular technology. It could be that in order to make that as part of a cell phone, you would need a lot of other licenses to other patents. So sometimes people have a misperception that if I hold the patent to it, that means I can make it and sell it. That's not true. What's true is that you have the right to exclude others from making and selling the item that's referenced in your claims. And what you need to get a patent, first of all, it has to be patentable subject matter. So it just can't be a great idea. It can't be something that exists in nature. If you discover gravity, that's not patentable. There has to be an inventive step there. Utility, and this is the easiest one to meet, and there's a lot of examples of funny patents out there to things you would never think would be patentable, and toys or things that you think would never actually ever be made. So the utility threshold is quite low, but there is a utility threshold. It needs to be useful. Novelty, and novelty and non-obviousness are truly the hardest ones to meet now. It has to be new compared to the prior art. And prior art is kind of a legal term that we use to say, what's out there known to somebody in this area, somebody who practices in this area, somebody of one of ordinary skill in the art. So if you're a chemist, you look to journals of chemistry, and you look to PhD theses, and you look to books, and you look on websites, and you look at YouTube videos, and you say, all right, is what I've done novel and different and new over everything else that's out there in this area? Novelty is also a reason why you need to think about public disclosure of what you want to patent before you patent it, because we don't want to lose global rights to protect your IP, and depending on how inventorship and everything plays out, you don't want to even lose rights in the US. So be very careful, and this is why when you go to a patent attorney for advice, the first thing they'll ask you is, have you talked about this with anybody else? Are you selling it today? Is it already kind of out there and the genie's out of the bottle, or is it still something that's novel that you haven't disclosed yet that we can protect? The second one of those pair that's difficult for patentability is non-obviousness. And this means that it can't be obvious if you combine a couple of different things. All right, so maybe what you discovered is novel, it's new, nobody else has done it. But maybe if somebody read some book and then they watched a YouTube video, it would have been obvious to try to combine the two things together to do what you did. And there's a lot of ways that you can argue back as you're doing your back and forth with the patent examiner about why it's not obvious. But again, this comes up frequently of something that you have to overcome. And then finally, the last requirement for patentability is enablement. So you have to teach and describe the invention. You have to let somebody else be able to make and use that without undue experimentation. And this is the quid pro quo that you get for that patent right. So you don't just get to stop someone else from using your invention for 20 years after the date of filing because you pay the patent filing fee and submit a piece of paper. The point is to further development in the arts and sciences, and so what the goal was that you teach somebody else all of this, and then they can build upon that. But in exchange for teaching someone else and making it so that they can do these things, then you get that limited monopoly right. And the process for patentability, I'll use the United States as an example. It gets a lot more complicated when we get into international filing. But we'll go from T0 being the time of disclosure to a patent attorney, where you're bringing what material you have. So we'll start at T0. you have this wonderful new invention or information or algorithm that you would like to protect. And then there's the preparation of the filing of the filing of the patent application. So there'll be a review of the prior art, and when we can say, hey, okay, what's out there? What is the examiner likely to come back with, and say perhaps, this might not be novel over that, and then we can see if there's additional data you should go collect, or if we should change the claims a bit so that we can make the claims directed to the specific points of novelty of your invention or your information, and then we file. And then there's kind of a back and forth negotiation with the patent office. So they'll write back and they'll say, yeah, okay, there's usefulness here, but I read these 3 journal articles and I think this is obvious. And then you have to write back and say, no, respectfully, you're wrong. And here's all the reasons why. This is the most wonderful thing under the sun. And that goes back and forth a few times. And then always being optimistic, you get your notice of allowance that your patent will grant. And this takes, I practice mostly in the biotech area, and in the biotech space, this takes about 3 years on average. So it's not an overnight process. Takes a little bit of time, can take longer, and especially internationally, it can take a lot longer. And then once your patent issues, you have a number of maintenance fees that you need to pay to continue that patent in force. And if you do so, then it will expire 20 years after the filing date. But like I told you before, don't get stuck on patents. Think big, right? So more than patents. So we'll talk about trade secrets for a few minutes so that we don't just focus on the one area of IP. So trade secrets, they're kind of the backdoor defender to IP. So here's some commonly recognizable examples of things that are trade secrets. So the formula for Coca-Cola, the wonderful breading that they're moving away from for KFC and going to grilled chicken. Certain chocolate chip cookie recipes, although they've been published on the internet fairly widely now that they're probably not trade secret anymore. And processes, chemical formulas, algorithms, computer code, all these things can be protected by, of course, patents and copyrights, but also by trade secrets. And it's important, a trade secret, there's legal statutes that talk about trade secret protection. And it's not simply, as a small business owner, a matter of saying, I'm going to keep this secret, I'm not going to tell anybody, therefore it's a trade secret. There's appropriate management of trade secrets so that if you need to, in litigation, you can defend and say, this was a trade secret, and I took that seriously. So these are some best practices for your reference when you come to managing trade secrets, particularly as an organization grows and you go to 10, 20, 30, 100 plus employees. You want to have a written trade secret policy. You want to restrict, of course, areas where you store this information from the public and then also from all employees. So it's a need-to-know basis. It's not everybody who walks in the door gets to see this. You don't have the formula for Coca-Cola hanging on a plaque for all the employees to see. You keep it restricted. And then you make sure that there's a process in place so before somebody goes and gives an investor talk or a speech or a poster presentation that you're not disclosing any trade secrets in those items. And the advantages of trade secrets, you don't wait that 3 years, right? There's no back and forth with the patent office. If you say something a trade secret and you manage it appropriately, it is a trade secret. You're not teaching the world how to make and use that invention. There's no quid pro quo disclosure requirement, and there's no 20-year term limit. You can keep a trade secret indefinitely. The trade secret to Coca-Cola is still a trade secret. There's also some disadvantages that come with that. So one is that it's difficult to maintain a trade secret for a long period of time, especially as your organization grows and people leave the organization. Did they take that with them? Were they one of the 6 people to know the formula for that? And are you going to send their new employer a letter saying, this person has now joined your organization. We wish to remind them of you that they had confidential information, including access to trade secrets, that they need to maintain as confidential, even post-employment. So it can be difficult to maintain such secret information for a long period of time. If somebody gets that information through reverse engineering, it's no longer a trade secret. And then they are more difficult to enforce than patents. You don't get the triple damages for willful infringement as you do with patents, and maintaining that over a long time is a long-term expense. but to talk about an alternative method of IP protection other than patents. That's in a nutshell kind of trade secrets. I won't cover copyrights or licenses in detail, but for reference, those were a few of the other ones too. Okay, so we covered Think Big. We covered our big Thanksgiving turkey of all of the intellectual property that you could possibly use. So now we'll move on to tip number 2 of our 5 tips. Think before you put that in writing, and some careful communications best practices around what you communicate relating to intellectual property. I have a lot of examples around this, so I put on this don't make me use my lawyer voice, because I'm frequently calling people saying, next time call me. We don't need this in an email. So some best practices are before you write an email or an investor presentation or a report to the board, or frankly, even a performance review for the end of the year, because I've seen this happen, you want to think about what you're putting in that material. Unless you're a lawyer and being asked legal advice, you do not want to put anything about the strength of your IP, the strength of a competitor's IP, anything speaking to your freedom to operate, or whether you need a license to someone else's patents, whether somebody else's copyright might be something that you're using in material. You do not want to interpret the terms of a license and say, hey, I think under this license we can sell these things. What do you think? Unless you're a lawyer giving legal advice, don't put that stuff in email. You don't anticipate this today, but if you end up in litigation, you will be deposed. You will spend hours being, walk through everything that you've said in this email and why you said it and what you were referring to, and then you'll get up on the stand and they'll have a big 4x6 placard on a poster board to show to the jury, and they'll say in your performance review, you said that you were going to analyze this company's IP to see how you could work around it so that you didn't infringe their patents. Is that correct? And you'll have to say, I guess that's correct, right? And then they'll walk through, okay, well, here are the things that you did that infringe those patents, and you knew about this clearly because you put it as part of your performance goals in your performance review. So it's best to just not put it in writing. If you need to document it, make sure you're using an attorney, and make sure that you are sending an attorney this information marked privileged and confidential, and we'll get into some of the details about the best way to put together that kind of a communication. I've seen this go wrong so many times, and I can't emphasize this part enough. You don't want to find yourself in this situation. So the best practice is to just call. Pick up the phone and call. Ask the question of a lawyer. Don't put anything in writing. The second best, if it's a patent question, to send it to a licensed patent attorney. Copy the people who need to know, not everybody under the sun, the people who are relevant to the information you're asking about. Mark the subject as privileged and confidential, and then give them the facts. Ask for legal advice. Don't say, I think we're infringing this patent because of what we're doing. Say, we are doing ABC. Could you please give us a legal opinion on any risks relating to those activities? That's going to keep you out of the witness stand. So here's an example, a real-world example from an Oracle trial about what not to do. So this email was sent by an engineer, and this one actually looks pretty good, and a long story even. This one was marked privileged to make it more interesting, but I won't get into those details. But the engineer said, hey, what we've been asked to do is to investigate alternatives to Java, but we've been over a bunch of these and they're terrible, so we think we need a license. So the judge actually pulled this up and said, somebody with the Magna Carta in this email could win this trial. It did not go well. And that's not the worst email I've seen. I've seen emails from scientists that say, well, I don't think these results are novel over these 5 journal articles that they'll send me. They're arguing against their own patents in an email. And that's not good either. And then they'll forward it to 5 other people without me being copied on it, and then someone forwards it to me later, and I see that now they've broken privilege. I've seen scientists, and there's something about scientists, they secretly would like to be patent attorneys, and so they like to use a lot of the technical jargon about prior art and novelty and infringement, and scientists will write these emails about, well, if we move this thing here, then maybe we're not infringing this patent. And then after an email string that goes on for hours and hours and hours, somebody will forward it to me. So don't do that. Many of you listening in or in the room might not know what this is. This is a telephone. This is from a lawyer's coloring book, actually making a lot of jokes about lawyers. But pick up the phone and call somebody. And even if it's somebody who's not a lawyer on your team, if you want to have these internal discussions about what you're doing, do it by phone or in person rather than creating email strings about it. And the second best thing to do, if you're not going to pick up the phone, is to structure your email in this way so that it's protected by attorney-client privilege, it's asking for legal advice, and it won't come up to haunt you in litigation. And this is not me, yelling at you. This is me trying to protect you because I hate seeing people go through that. All right, tip number 3. Think offensively and defensively like the Cyclones. So I don't think there's a way for me to play this. This is actually a video of the last game that we just had. I got to sit behind the cannon, and the cannon went off a lot of times, and it was really good seats. So what is your game plan, right? I mean, don't just think about getting your patents, building your chest of achievements. Think about defense. Who else is operating in this space? What are competitors doing? Take a look at their patents and their patent applications. Make sure you review that. Looking at your game plan, what are the activities that you're doing today, and where you think you're trying to build your business in 1, 2, 5, 10 years from now? What countries might you be going into if you're looking at expanding internationally? What's your secret sauce? What's the most fundamental thing that's important to your organization going forward? And your competitors or others, are there any other IP assets there that might be a problem? So think from both sides of the fence. Tip number 4, think long look. So the patent landscape does change every single week. New patent applications publish and new patents are granted. So you may have hired a patent attorney to do a review for you 4 years ago as part of your initial business plan, looking at what the other patents were in this space. And today, that's going to be totally different, especially in a biotech field like gene editing that I work in. It's constantly changing, and you don't know what's out there that's just waiting to publish. You have to review those things periodically. I mentioned before that asking, is it patentable, is the wrong question at first to ask. So in your long look thinking, don't think immediately, is it patentable? Think, what am I doing with this? Am I going to be monetizing this technology 5, 10, 15 years from now? Or is this a product, is this a widget that's going to be on a shelf that's going to be sold for 1 year, and then I will have a version 2, version 3 that will be so different that this one will be obsolete? If that's the case, why go through all the time and expense and 3+ years to get your patent application if you're not going to want to exclude others from making, using, and selling that? Unless, of course, there's the public recognition or the investor recognition or other reasons that you want the patent besides business value. But think long look. And then finally, think partnership. This broadly, broader than IP, relationships and partnership are the most important thing. And I was a business person before I was a lawyer, so I think I can say this credibly, but most important thing is partnership. Who you do it with is more important than what you do. But think partnership when you're thinking IP, and find an attorney who will partner with you on how, and not just the one who will tell you no. So it can be a very easy place for attorneys to tell you the 15 reasons why you can't do something, or the several problems that you may have in a license agreement, or all of the issues that you may have with other people's patents and working around them. You have to decide your company's risk tolerance, because if you eliminate all legal risk from what you're doing, that's the quickest way to shut down a business. And my dad's an entrepreneur, and I've seen other small companies go through this. You have to know what your risk tolerance is, or what your board's risk tolerance is, as you're making these decisions and moving forward. It's never going to be, there's a risk, so we won't do it. You have to know what that risk tolerance is. And then relating to license negotiations, I frequently will see companies spend months arguing about the minutia of a license of a multi-million-dollar, multi-year deal over the indemnification clause is one example, or some other small areas. If you're trying to approach this from a long-term relationship perspective and building trust and working on great things together, you have to think about the potential harm you're doing to the relationship to delay it over these things. And sometimes if their choice of law or indemnification are my two that I go to, and I'm sure it's because I'm not an attorney, I'm not a commercial attorney by training, I'm an IP attorney, so those things aren't as interesting to me. But in my opinion, if you're arguing over choice of law for 2 months, if you get to a point in your relationship with this licensor and licensee that you're having to worry about those things, you're sunk anyway. The deal that you are striving so hard to accomplish is over if it comes to that point. So weigh the time and the money that you spend appropriately in license negotiations, depending on what's most important to you in the relationship. So those are the top 5. So think big, think before you put it in writing, think offensively and defensively, think long look, and think partnership. And with that, we'll open it up for questions. I'm happy to see if we can help, and we'll also cue the folks who are participating remotely to see if they have any questions as well. Yes?
Question in that processes of that. Okay, now when it comes to software, which is most often copyrighted, right? Suppose you have created a particular programming logic using a unique set of, say, data containers, which constitutes a process to impart a particular effect or outcome in the medical field. Would that then be a patentable process, or would that be something in the realm of copyright?
So the question for those of you remotely and watching this later is basically around software patents, and if you have an algorithm of a certain type with certain buckets relating to processing of information for medical reasons, is that something that would be patentable, or could that just be covered by copyright? And the answer, as it always ends up being, is mostly it depends, but I'll give a few scenarios. So the first, you have to look at the other prior art that's out there. So you'd want to do a patent search to see, okay, let's search for other patents in this general area and see what we might find. What are some relevant journal articles that you've read to help come up with this? What are the things that are different about what you're doing versus what is out there already? And then the second thing would be there's kind of a new 2-step test at the Patent Office for software after a case in Ray Alice that talks about what you need to rise to the level of patentability. So you'd have to see if you met those criteria. It's got to be more than just an algorithm in some. So you'd have to see whether it was patentable. And then thirdly, the point about do you want to patent it? So you have to teach someone else how to do all those things. If the claims that you would end up getting are so narrow, then it wouldn't make sense to patent it, because then you're basically teaching someone else who could then pivot it and use it slightly differently, but not infringe your patent, which is relating to the prior art search. So it depends, and those are a few examples of the information that you'd need to find that answer out. Are there any questions on the web? Nope, so far so good. How are we doing on time? Oh, we're doing really good on time, actually. I spoke too fast. Yes, Mr. McKee.
Routinely, correspondence be marked privileged between client and attorney?
That's a great question. So the question was, should correspondence between a business person and an attorney routinely be marked as privileged and confidential? And the answer is a very strong, absolutely not. So an organization has been sanctioned in trial for doing this. It can come across as using it as a shield inappropriately to try to keep everything out of litigation. And if that's the case, then privilege is broken and all of the information becomes relevant. So you do not want to say, well, if it's safer if we do everything with privilege, just copy a lawyer on our business plan, copy a lawyer on anything we do, even if it's not asking for legal advice, and mark it privileged, because it's stuff that maybe we're not so sure it's good that we're doing, so we're going to mark it privileged and then go forward with it anyway. That is not good. So you draw the question is, how do you know where to draw that line? And you draw that line about seeking legal advice. So you need to cast your correspondence as a question to the lawyer. So it's not sending an Excel spreadsheet with the marketing plans for a product to the business team and copying the lawyer, marking it privileged, and say, you know, here's all the marketing plans for the business team for when we're going to sell this product, and all the money we're going to make based on the pricing assumptions that we've made. You want to send it to the lawyer, copy the, you know, if it's the sales team that's relevant, copy the relevant people on the sales team and say, here's our marketing plan and the timing for which we want to sell product. Could you please let us know if you see any legal issues in the license agreement or relating to IP in meeting these goals? So that's cast as a legal question, you're asking it of an attorney, and you're marking it privileged, and that checks the boxes. Any other questions? All right. Well, then I'd like to thank you again for the opportunity to be here this morning. And if you have any questions, my contact information is on this last slide. Please feel free to connect. Thank you very much.